May it please the court. The 14th Amendment protects against racial discrimination, and thus race-conscious affirmative action must be judged on the classification of strict scrutiny. Compelling state interest is satisfied by narrowly tailored means must be proven.
Abigail Fisher, who was not in the top 10%, was denied admission after review under the holistic admissions process that considered race as one of many factors. Though the plaintiff was discriminated upon by her race, affirmative action passes strict scrutiny and is therefore consistent with the 14th Amendment, as well as other historical evidence.
Cases such as Bakke and Grutter have proven that has established that the compelling state interest is diversity. And narrowly tailored does not mean exhaustion of every other conceivable means, and we get that from Grutter. However, it does require serious consideration of efficient race-neutral alternatives to satisfy narrowly tailored, which the University of Texas at Austin has shown.
Socioeconomic and geographic affirmative action and the top 10% plan do not increase minority representation as efficiently as race-conscious affirmative action. Race-conscious affirmative action is the best method for achieving diversity because it does so with as little discrimination as possible, flexibility in its method, and with a limited duration on the relief.
You ready for questions? How should this court evaluate race-conscious university admissions programs? Please cite specific Supreme Court cases.
Well, because it is race-conscious affirmative action, we're going under the standard of strict scrutiny, which requires a compelling state interest. And in Bakke, we see how diversity is established as the compelling state interest.
The court should also use the method of applying a narrowly tailored test and the method that they should use to apply and determine if race-conscious affirmative action is narrowly tailored comes from Powell's concurrence in Full Love v. Kolesnik and Brennan's plurality in U.S. v. Paradise, in which the three evaluation techniques that they used were the efficiency of alternative methods, flexibility of the discriminatory method, and the limit of the duration.
And also we see how in Seattle v. Parents Involved, how you need to look at how race is a factor, because in this case, race is the only factor, which is why the school board's method of increasing diversity was unconstitutional. In addition, we should not...
In the parents' case, race was the only thing.
Yes. And
are you arguing the University of Texas at Austin race was the only one?
No, in the University of Texas, race was not the only sole factor, which is why you can't compare the case in Seattle, what the Seattle school boards were doing, with the University of Texas, because the University of Texas, they considered many other alternatives, and race wasn't the only factor. In addition, in the Ricci decision, they were mainly looking at disparate impact, while in this case, we're looking at what is narrowly tailored, and the steps that the University of Texas has taken to ensure that they consider alternative motives to increase diversity.
And the University of Texas only using race as one factor in their admissions is not mechanistic and passes the Grutter test.
Has the University of Texas shown that its use of race as an admission plus factor meets the strict scrutiny test? Can you explain strict scrutiny and how it applies to this case?
Strict in name, fatal by practice, strict scrutiny is the hardest test that any law will have to pass. Any law dealing with race, national origin, ethnicity, or religion must meet the requirements of strict scrutiny to be deemed constitutional. These requirements include the law to have a compelling state interest and to be narrowly tailored. Race-based affirmative actions, therefore, must satisfy this form of judicial review because, well, they're dealing with race and therefore are under strict scrutiny. And that, of course, applies to our case, Fisher v. Texas.
The admissions process only uses race as one factor. It's not mechanistic. It's also the only way that the school can get racial diversity. According to the UT Office of Enrollment Management and Analysis, in 2008, only 19% of the students were actually admitted under the holistic review process, so it's a very small amount of the college that's admitted. In addition, 52.3% of the freshman class in 2008 were white, and most of them were probably admitted under the top 10% law.
Does the language of the 14th Amendment support the notion of race-based affirmative action? Why or why not?
The 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. And while this may sound like it does not support our case, the distinction it makes is that the law is applied differently to minorities, creating social disparities in America.
And we see that especially with incarceration rates today in America and how they affect minorities. For example, according to the 2010 census, for every 100,000 African Americans, 2,207 of them are in jail, compared to only 380 per 100,000 for the white population. 2013 data from the U.S. Department of Justice shows that African Americans are incarcerated at a rate of 37%, or within the entire prison population, 37% of them are African Americans, which is the largest population in terms of demographics. In addition, African American women are incarcerated at literally twice the rate of white women. And this leads to 3% of all African Americans being incarcerated compared to only 0.5% of the white population.
Okay. Looking at legislation passed during the Reconstruction era, does the weight of historical evidence support affirmative action programs? Why or why not? In answering this question, please cite specific of the following pieces of legislation.
It totally does. We see on the Act of March 3rd in 1865 the creation of the Freedmen's Bureau, which is essentially one of the first affirmative action programs ever. It was originally only created for 1 year to help freedmen during Reconstruction. However, on the Act of July 16th, 1866, the Freedmen's Bureau was actually extended for another 2 years.
And the Act of July 25th terminated the Freedmen's Bureau, but it allowed the extension and continue of the educational branch. In addition, the Act of June 21st, 1866, which chartered the Howard University, which was a specific university that was made to bring higher education to freedmen. Those both show that education is an especially important and well-promoted part of society, especially for one race.
Explain the Freedmen's Bureau. Does this post-Civil War program provide support for affirmative action extending to modern-day programs or not? What arguments were raised by proponents and opponents of the Freedmen's Bureau during the Reconstruction period?
The U.S. Bureau of Refugees, Freedom, and Abandoned Lands was a federal government agency established in 1865 to aid recently freed slaves during Reconstruction. And they played a very integral role in, one, reconnecting families, educating newly freed African Americans, because the majority of them were illiterate and needed to learn how to read and write. And they also served as legal advocates for African Americans on the national and on the state level. They also encouraged African Americans to seek employment and to eventually achieve economic liberty. It was one of the first affirmative actions programs in United States history, with some of their goals and their methods similar to universities all across the United States. I'm, of course, referring to affirmative action here. As previously mentioned, the Act of July 25th, 1868 allowed the Bureau to continue with efforts to improve educational opportunities, even though the organization was technically dismantled.
Senator Sumner promoted the Freedmen's Bureau in saying that we needed relief in a temporary period of transition in which there would need to be aid so that society can help minorities that have been disadvantaged, especially the slaves at this time. And Hendricks, however, argued that it exceeded the powers of Congress, but parts of the 14th Amendment we see are showing support for the Freedmen's Bureau.
And also, more arguments. Cohen argued that this preferential treatment was discriminatory, which sure is true in terms of race-conscious affirmative action, but the programs we see, especially at University of Texas today, and the ones that do exist today, aren't narrowly tailored enough to pass the strict scrutiny test. In addition, with the 44th Congress First Session in 1875, Blaine, who proposed ending this elected committee on the Freedmen's Affair, there's less equality for minors as there is today, but legal equality is not the problem. What we're really seeing is how the minorities today are disproportionately disadvantaged, and that still lingers on in today's society.
All right, let's jump to the last question. What do you make of the argument that we should live in a colorblind society and thus not ask, students like Abigail Fisher what her race is?
I think that there's a big difference between a colorblind society and a race-neutral society. To be race-neutral is to try to promote race without doing it in a way that considers race, but colorblind would be not considering race at all, and if we were to be colorblind, we would just be continuing to bridge the gap between races.
So you think it would be successful at bridging the gap or unsuccessful at bridging the gap if we pursued a colorblind society?
It would make the gap bigger between minorities, making African Americans lesser and bringing in whites up.
Okay, thank you.